Today's Supreme Court case involving Microsoft and overseas data puts a familiar tech issue before the justices, the balancing act between the interests of law enforcement on one side and privacy interests on the other. Immigration has also been a key issue this week for the justices. And as always, Marcia Coyle of the National Law Journal is here to explain. Hello, Marcia.
Hi, Judy.
So let's start with the argument that the justices heard today, this dispute between Microsoft and the federal government. We know it started a few years ago. Federal government had a search warrant for Microsoft. What was that all about?
Okay, this warrant was not what we often talk about, a Fourth Amendment search warrant. This warrant was for emails that the federal prosecutors believed were important to a drug trafficking investigation. The emails were on a Microsoft server in Dublin, Ireland. But the warrant came through the Stored Communications Act of 1986. And Microsoft said that act does not apply outside of the United States and objected to the warrant. The lower federal appellate court agreed with Microsoft. The Justice Department brought the appeal to the Supreme Court. So the arguments today, we're going to focus on whether the act applies outside of the United States. What really does this act mean?
And remind us, why did the federal government want these emails so badly?
Again, because they believed they were integral to the government's investigation of drug trafficking.
Right. So what kind of conversation or discussion did you see?
Well, right away, there were several justices who were concerned about how to apply this 1986 law to modern technology. Justice Ginsburg, for example, said back in 1986, no one ever heard of clouds. And she wondered, wouldn't it be better to leave things as they are? We have to give an all or nothing decision, but Congress can take account of all the nuances, the new technology. Justice Breyer also said, is there any way we can read the language in the act to adapt it to modern times? But lawyers on each side said that the duty of the justices was to interpret the act. So what do? Well, the government's attorney said the focus of this law is disclosure. And once Microsoft retrieves these emails, disclosure occurs in the United States. So the act is not being applied abroad. The Microsoft lawyer said, no, the focus of the act is securing the security of these electronic communications. And going into Ireland to get them is invading a sovereign interest that has its own laws about storing communications.
Could you tell anything about the kinds of questions, the differences in the kinds of questions the justices were asking?
Their concerns were different. I would say Justice Alito, for example, seemed sympathetic to the bind the government was in. He said the government could have probable cause that a U.S. citizen committed a crime in the United States but couldn't get emails to prove it because they were stored abroad.
Well, this is one that a lot of people are watching for just so many reasons, because tech has become an issue increasingly before.
And lots of friend of the court briefs were filed by tech companies, civil rights groups, privacy groups, nations.
So separately, the justices weighing in on immigration, they handed down a decision today following something that they made a decision on yesterday, which I'm going to ask you about in a moment. But today, Marcia, they ruled on a case that has to do with undocumented immigrants in this country and how long and under what circumstances they can be detained.
That's right. There were really three groups of detainees that were at issue in this case: asylum seekers, detainees who had committed crimes but had completed their sentences, and then another group that felt they had a legitimate claim to being in the United States, but their claims haven't been heard. Well, the lower federal appellate court had looked at federal immigration law and ruled that these detainees did have a right under the law to bail or bond hearings, and said every 6 months they should be reviewed to see if they posed a danger to the community or to themselves, or could commit a crime. it didn't guarantee that they would be released, but they at least had the right to a hearing.
Now, one of the things that was interesting today, Justice Breyer went to some length to read an entire dissent, which was what, 30-some
It was
pages?
a summary of it,
A summary of his
a long summary.
a long summary of his dissent. But here I'm quoting from part of what he read. He said, "No one can claim, nor since the time of slavery has anyone to my knowledge successfully claimed, that persons held within the United States are totally without constitutional protection."
Yes, he was upset that the majority, which ruled against the detainees in this case, seemed to say that because you come into this country illegally, you are really not in this country. And so there are no rights that apply. And his quote, as you just read, says that's just the opposite, that we've, since before slavery, if you're in the United States, the Constitution applies. He read a summary of his dissent. That's an indication of how strongly he feels. I should say, Judy, that this case will go back to the lower federal appellate court because these detainees have also raised constitutional claims. The issue before the court was federal immigration law, a statutory interpretation. So that lower federal appellate court now can decide, whether one, it can rule on their claims and then actually rule on the claims. Case may come back to the Supreme Court.
And as we pointed out, this on the heels of yesterday's decision not to hear the case at this point on the DACA.
That's right.
The young,
all the court
undocumented
did
immigrants.
yesterday was say it would not leapfrog a lower federal appellate court, which already had the government's appeal before it. It will wait to see what that court does.
Marcia Coyle, the National Law Journal. Thank you.
My pleasure, Judy.